Okay, we ready to go there? Can you hear me in the main jail?
Good morning. Good afternoon, Judge.
Good afternoon, Counsel. All right. First case up is a long one. Mariuzzi Gastelo late. Say late?
She
I'm not even close.
She's at North Broward, Judge.
Thank you, Counsel.
Mr. Offstall, this is a co-defendant of Alejandra Acosta, who was in this morning.
Your Honor, you're talking about Gastaletazzi Merizuzzi?
Yes.
She's on the phone with your pretrial release down there right now. She's at North Broward. She's on the phone with pretrial.
We'll recall the case. Thank you.
I'll let you know as soon as she's off the phone.
Thank you, sir.
All
right. Romaine Orisma?
Yes, sir. Present at the main.
All right, Mr. Orisma, you're charged in one count of touching or striking during a domestic violence event. You're charged with simple battery, a rape petition. There's probable cause to believe you may have committed the offense to which you're charged. The victim apparently is your mother, according to the PC. Does he have any kind of record, Mr. State Attorney?
Yeah, sure. Just one moment. It wasn't declined. I understand it wasn't declined. This makes no sense. Your Honor, he just had a domestic violence battery dropped beginning of March against a different alleged victim.
All right, sir. Find a probable cause in your case.
Judge, brief argument.
Yes.
Just would argue that the touching in this case was de minimis, and both witnesses are reluctant to cooperate with the state.
All right, but the victim does appear to be his mother. I set the bond in the case at $1,000. Order no contact with the alleged victim, which is Clamine Orisma. That means you cannot contact her directly or indirectly under any circumstances. Mr. Orisma, do you understand? You understand?
Yes, sir.
All right, good luck to you, sir. The bond will be $1,000.
Thank you.
Sir, did you have a case? Counsel? Did you have a case?
I'm here with the public defender for the city of Fort Lauderdale with Mr. Java.
Oh, you're on the municipal cases?
Only, yes,
okay,
sir.
All right.
Thank you.
I think those are coming up. I don't know when.
Thank you, Judge.
Judge,
Yes.
Merizuzzi is ready at North Broward if you want to see her.
Thank you, Counsel.
Come on in, stand in.
Judge, her co-defendant was here this morning. Judge Hurley released her on our own recognizance. I see there's a probation violation there, too.
Yeah. She's got a VOP. All right, ma'am, you're charged with one count of touching or striking during a domestic battery. You're also charged with a violation of probation or community control. I find probable cause on the touching and striking and on the VOP. Because the incident involves a minor child present when this occurred and a knife, I'm going to set your bond in the... Does she have any record, Mr. State Attorney?
Your Honor, in addition to the case she's on probation for possession of marijuana 2011 and a grand theft 2009.
Okay. Probable cause indicates that after the incident occurred, you returned inside the house with your mom and nephew and began throwing things at them, but allegedly picked up a knife and attempted to throw it. However, the mother stopped her prior to her throwing it. In count one, I'll set the bond at $2,500. In count two, there is no bond at all because it's an allegation of violation of probation or community control. You'll have to see the division judge. So should you make this bond, ma'am, under no circumstances or do you have any contact with the alleged victim here, which appears to be your mother. Her name is, can someone help me on the PC?
What was that amount?
Yeah. Right. Maria Castillo
Yes, Dale.
and the suspect's sister Alejandro Acosta. You can have no contact with those persons under any circumstances.
2,500. I'm sorry.
Sorry. Do you understand, ma'am?
Yes, sir.
All right, good luck to you. Your bond is $2,500 on the pending case with the VOP.
Sir, is there any way, I was just in a car accident. I'm in very bad shape. Is there any way that I can, be released and then go to, if you
ma'am.
can help me out with my no
You
bond?
can't be released on a VOP, no ma'am, but if someone in wants to, in the courtroom wants to write an order for me to have you assessed by the medical personnel, I'll do so. But you can't be released on a VOP, but I'll ask that someone in the jail attend to you, see if you need any medical treatment, and if so, they'll make the decision about where to put you or where to send you if you need medical care, all right?
Okay, thank you, Judge.
All right, good luck, ma'am. Shakira Rolle, R-O-L-L-E.
That's a misdemeanor ordinance case, Judge. We don't have all the
That's
parties
North
present.
Broward again, Your Honor. That's a medical reset.
Oh, medical reset, thank you.
Yes, please.
All right,
Back to
Rolle
one.
will be reset. Jennifer, sorry? Set it tomorrow, I guess. Yeah. Jennifer Bolanos? Is that you, Jennifer?
President, the main judge, we have an argument regarding probable cause.
Okay, I've read the PC. What's your argument?
With regard to both count 1 and 2, the arresting officer indicates that those items were recovered, does not indicate who possessed them. Therefore, there's no probable cause to charge her with possession. Specifically with regard to count 2, it's untested. Therefore, there is no probable cause to believe that it was a controlled substance. So I would argue no PC in either count, or in the alternative, no PC for count 2. We'd ask the court to ROR her on all counts or to consider pretrial release. I have some community information if the court would like to hear that.
I think you're probably right about the second part on the Xanax. Yes. 3 counts of battery on a law enforcement officer out of Dade County. Okay.
And, Your Honor, and I don't have any other priors, and I have no argument as far as count 2, Your Honor.
Okay, but so his originating PC relates to, it says that the defendant was a front seat passenger of the listed vehicle.
Yes, Your Honor.
They did a search with a canine and found Valtex positive on the cocaine, which would be the bondable offense here, it seems like.
Right, Judge, but that doesn't say that it was
Right.
found near
I'm with you
within
on
her.
that. I'm with you. That's why I'm asking the state what his position is.
Your Honor, for the cocaine, I would just argue that I believe there's probable cause for the arrest. If we were at a trial where there's a higher standard, no. Would this suffice? Absolutely not. I'm just arguing for a lower standard probable cause. I do believe it suffices. I'm not going to argue count 2 at this point in time.
Response, Judge?
Yes, sir.
Regardless of whether we're in a trial posture or at probable cause level, they still have to list the elements. There is no probable cause that she possessed it, especially since she's a passenger of the vehicle. There's no allegation in the probable cause affidavit that she possessed it. All they're saying is they recovered it. They didn't say from where within that vehicle that doesn't belong to her. So I would argue there's no probable cause.
And, Your Honor, my argument would be under constructive possession, not actual possession.
Well, how would she have knowledge?
Okay, I don't need 2 lawyers to argue the same motion. I tend to agree with the defense in that if it would have said in the PC that the cocaine was found in the console, was found in the glove compartment, was found somewhere in the front seat near the defendant, then it would be constructive possession and there'd be PC. But it just says, I stopped the car, I had a drug dog do a search, and we found cocaine.
I would just ask for time to perfect that, Your Honor.
I'll give you 48 hours to perfect. I find no PC on count 2 and 48 hours to perfect on count 1.
Your Honor, I would just
Judge,
ask for time on both then.
Okay, I'll give you 48 hours on both.
Thank you.
Judge, I don't believe that the state has a good faith basis of going forward on count 2. They're not going to, in 48 hours, get the lab to test it, Phil. I would ask the court to ROR her on count 2.
Sir, I'm not, okay, well, I'll RR on count 2, but I'm not on count 1.
Well, Your Honor, and
Thank
I would
you,
ask
Judge.
the time for the 1,000 count too. The officer put down due to his training experience.
I'm gonna let you,
But he's asking that it be ROR'd before I even have a chance to try to come back and perfect on it.
well, I'm giving you 48 hours to perfect. She's asking, aren't you asking me to ROR him on that count? Is that what you're asking?
Judge, while the 48 hours, I'm asking the court to ROR on count 2, give the state 48 hours to perfect on
What's the
count
effect of
1.
count 1 if I ROR on count 2? Because I'm not letting her out on ROR with a Dade County 3 pending charges against battery on a law enforcement officer. I'm not RORing her on these 2 charges.
And all I'm asking for, Your Honor, is for the 48-hour period to leave both bonds at 1,000. If I come back and there's probable cause, then whoever's here can deal with that. If I can't fix one or both of them, then she'll be ROR'd on those counts.
Okay. All right, again, I'll make a compromise on this. Good, bad, or indifferent. I'll ROR on count 2. Count 1, the bond will be $1,000. You're allowed 48 hours to perfect on both, sir.
Thank you, Judge.
Thank you, Judge. Good luck.
On count 2, yes. Antoinette Roper? Possession of cocaine? She posted bond? Is that what she said, sir? All right, she posted. Let me see. Latoya Brown?
She posted bond also, Your Honor, North Broward.
Thank you, sir.
Judge,
Yes?
Patricia Coate on page 2 of your docket.
North Broward.
That was a reset from this morning. I think she's waiting for
Brown
her attorney.
Latoria posted bond also.
Who did?
Brown Latoria.
Okay, we got that. But you were saying something about someone else.
I'm sorry, Judge. On page 2 of the docket, Patricia Coate was a reset from this morning. I believe we were waiting for her attorney.
Anybody know anything about that?
I believe Judge Hurley called the attorney in the morning, left a message. Am I correct?
We still haven't heard from her lawyer. So
Noted. Thank you, Judge.
I don't know if I have the paperwork, but I'll call the case if we can get the lawyer over here. You just be on standby. Back to the main jail. Kenneth Stein.
He's present at the main judge. Josh Rydell is his attorney. I was unable to contact him. I do have the phone number.
Okay. We'll try to contact him again. Could you give us that number?
The number I was given is 954-779-2711. Is that correct?
What was his
Yeah,
name?
but I'm not positive on that.
Josh Rydell, Judge.
Rydell. Can someone try and get a hold of Mr. Rydell for me? Someone in the courtroom. Here's the phone number if you all need it. We'll see. We'll recall his case. Just tell him to be
Right there.
patient. Terrell James. Terrell?
Mr. James is present at the main judge.
Yeah, this was the fight. There were 2 people involved. Well, let's see. First off, I'm going to find probable cause. You're charged with touching or striking during your battery. I do find probable cause based on the PC written by the police officer at the scene. Let me find out what his record is first.
One moment, Your Honor. I'm pulling that right now.
How long have you lived in Broward County, sir?
Judge, he's been here all his life. He's been at his current address for a few years. He works in lawn service. He takes care of 3 children, aged 5, 3, and 4 months. Strong ties to the community through his family. He does have some money in the bank. No real estate. Not sure who's going to help bond him out. I would argue that this is a mutual combat situation and that he should be ROR, Judge.
Your Honor.
Mutual combat or just a fight?
Mutual combat, just a fight. There's a case called BB v. Foster, BEBE v. Foster, which would I think it was. I can't say what court it was, but they basically said that it was when 2 people agree to fight, that you can't charge them with battery, either one of them with battery, because they agreed to fight. It's mutual combat.
All right.
They use the word fisticuffs.
Let me see what his record is.
Terrell James is currently out right now on 1 case for improper exhibition of a weapon. He's out on the 2nd case for felony grand theft, 2013 theft. And from what I can tell in the PC, the weapon offense involves one moment, Judge, a black 6-hour 9mm handgun.
When you say he's out, he's on probation?
No, they're both pending.
They're both pending. Okay. All right. On the touching or striking, I find probable cause because of the nature of the way the PC is written. I'll reduce your bond to $500, conditioned upon you having no contact with Daryl Keith Roach. That means you can't contact him directly or indirectly under any circumstances until this case is resolved by the court system. Do you understand, Mr. James? Is that a yes?
Yeah.
All
Yes.
right. That'll be your bond. Good luck.
Thank you,
to
Judge.
sir. Next case is,
I don't know.
the companion case is Daryl Roach.
Mr. Roach bonded, Judge.
He bonded, thank you.
Okay, you need to go ahead and sit down somewhere.
Michael Lee Jones. Michael Lee Jones. All right, sir, you're charged with 4 counts today. Driving under the influence, carrying a .15 breathalyzer test, DUI property damage, DUI first offense, failing to drive in a single lane, resulting from a traffic incident. I've reviewed this lengthy probable cause affidavit and find there's probable cause to believe you may have committed one or all of the offenses to which you're charged. I see someone from pretrial release standing up. Do we have any record on this gentleman, please, Mr. State Attorney?
Looks like he has some old priors out of Michigan.
Michigan?
Yes, and I'm talking about like early 80s, and they're not for a DUI or anything alcohol related, from what
All
I
right,
can tell.
let me just see if I have his driving record, just in case.
And if you don't, Your Honor, I checked his driving record. It is clean. His license was valid before the incident last night,
Okay, clean driving record.
or at least his license in Florida.
All right, sir, if I place you on pretrial release, you have to meet all the conditions of pretrial release, which means you're going to have to pass a random urinalysis, and you're going to have to comply with everything they tell you to do, or you possibly will be picked up again and brought back to set a bond. Do you understand?
Yes, sir. Thank you, Judge.
Are you going to be able to follow all the pretrial conditions, sir?
Absolutely, sir. Absolutely.
All right, you'll be placed on pretrial release. Good luck to you, sir.
Thank you.
Yes, the bond.
On the middle aisle.
Oh, no, the
outside.
pretrial release. ROR, all of them, pretrial release. Patrick Vattel. Patrick?
Yes, Your Honor.
Patrick, you're also charged with 7 counts with reference to a stop here in a motor vehicle. I've reviewed this probable cause affidavit. It's rather lengthy, including all of the sobriety tests that you were given at the scene. Count 1, you're charged with DUI or property or damage to a person or another. Counts 1, 2, and 3. DUI, alcohol or drugs, first offense. Driving while your license was suspended, second offense. And 2 traffic violations: failure to use a seatbelt, failure to use due care, and improper backup. I find probable cause on all 7 counts. Let me look at his. Here's his driving record. Do we have a record on him, Mr. State Attorney?
He's had some arrests, Your Honor, out of Dade, but it appears that they were all dropped.
Okay, his license was suspended 7/28/2014, and it was suspended. Looks like for the same offense, for failing to pay traffic fines. He also has, looks like 1, 2 counts. Driving while his license was suspended in 04 and 05. So apparently he's driving without a license and not complying with conditions. So with respect to count 1, on the DUI on property of another, count 1, count 2, and 3, I set the bonds at $1,000 each on those 3. On the driving while your the DUI alcohol offense, I'll set the bond at $500. Driving while suspended second time, I set the bond at $1,500 because of the multiple times you've been stopped and Your driving record reflects driving while your license was suspended. I'll increase the bonds in those. Zero bond on count 6 and count 7, so 2,000, approximately $5,000 will be your bond, sir. Now post those bonds and see the judge. Good luck to you.
No one tells me
Garfield?
nothing.
Clerval? Garfield?
He's present at the main, Judge. He's declined the public defender.
All right, you declined the public defender, sir. You're here on a capious, suspended driver's license, first offense, out of the county court. What's your address, sir?
Later.
6520 Southwest.
All right, they're telling me in the courtroom your bond's been posted, sir. You'll be released, okay? Good luck to you.
Good luck.
I find probable cause in the case.
Matthew Kelly.
Matthew Kelly.
Mr. Kelly has declined the services of the public defender, Judge.
All right, thank you, sir.
Todd Carroll. Todd.
Sir, you're charged with 3 cases today. Battery, touching or striking, damage to property, criminal mischief, and resisting or obstructing an officer without. Your bonds have been posted, sir. You'll be released soon. You'll have to face the judge and answer to the charges. Good luck to you.
Your Honor, we just asked for an order of victim contact.
Oh, wait a minute, sir. Hang on. Sir, I did read this. This relates to destruction of a barbecue grill at somebody's house. Should you make this bond, which I'm led to believe you are, you're to have no contact with John M. Hickey, who claims to be the victim and lives at 2134 Lincoln Street. Do you understand?
Yes.
You can't contact him under any circumstances. I read what was going on between you two. Until this case is resolved in the court system or until a judge orders otherwise, do not have any contact with Mr. Hickey. Do you understand?
Okay.
Good luck to you, sir.
Thank you. Thank you, Judge.
Todd Carroll. Todd?
North Broward. North Broward.
All right, good morning, Mr. Harrell. You're charged with, Carroll, you're charged with petty theft. Give me 1 second.
Yes.
Judge, would the court be amenable to resolving a case like this if Mr. Carroll wants to resolve it?
Large bottle of wine in the restroom, $12. He consumed half of it, so I guess we didn't recover the merchandise. What kind of a record does he have, Mr. Attorney?
He's got 2012 out of North Carolina, a DUI out of New York, theft from 2004 out of, I don't have a disposition on that, out of Key West, a trespass from last year, and a trespass from 2013.
That's it?
That's all, Your Honor.
You don't have a permanent address, sir, or do you?
I currently do not.
All right, I'd be inclined to
I
accept
was.
a plea of no contest on this and sentence him to time served on the charge of petty larceny if he's inclined to accept.
Sir, do you want to resolve your case or fight your case? It's up to you. The judge would
I
be...
would like to resolve it.
Okay.
All right, so I'll resolve your case by accepting a plea of no contest to the charge of petty larceny or petty theft and sentence you to time served in this case. But I'll also pose a condition that you're not to go back to this location where this incident occurred and you locked yourself in the restroom, which is located at 2150 East Commercial Boulevard. I don't know what is located there, but you're not allowed to go back there as a condition of this. Do you understand?
I do understand, yes.
You wish
Thank
to
you.
resolve your cases and accept time served and take a no contest plea to the charge of petty theft?
Yes.
All right, I'll make that finding, and that'll be the disposition. You'll be released today. Good luck to you.
Thank you, sir.
Accept the plea of no contest to charge of petty theft. Sentence him to time served. Yes, sentence him to time served. I don't know about these municipal cases. You guys have to let me know what he's doing. I know we're doing them at 2 o'clock.
Judge, the attorney for Kenneth Stein is present here, Joshua Rydell. That's the case you wanted us to contact. He's...
All right, let's go back to the main jail.
Good afternoon, Judge.
Counsel, how are you? Sir, could you bring up Mr. Stein?
He's coming, Judge.
Mr. Stein, his lawyer's here. Mr. Rydell's here. Mr. Stein, Kenneth Stein.
The mic is live, okay?
Can I talk to him first?
Well, hang on.
I have some pertinent things to.
All right, well, you might, but just hang on a second. Do you want to go talk to him? What do you want to do, sir?
I'd like to talk to him.
Yes, I do. I have some pertinent
Go
things
talk
to
him.
tell him.
If I'm here. If not, he'll be reset till the morning. Oh, you want to
Thank
call
you.
him there?
Thank you very much, sir.
All right, they're going to make contact with you, sir. Just they'll let you know in the jail what to do. Just have a seat. Nicholas Wren. Nicholas? No? You can't hear? Or is it me?
I'm sorry, Judge. Apparently, the sheriff's not going to allow the conversation to take place here in the courtroom. They're going to have to figure out something else.
You guys got to figure something out. Is what they're saying. I don't know. You're welcome.
I don't know.
You want me to recall his case? Mr. Rydell?
Recall it, Judge.
Huh?
We can recall.
Okay,
If I don't have
bring,
the ability
bring
to
Mr.
speak with
Stein
you.
back up then, please. Mr. Stein, you're charged with 2 cases today: disorderly conduct or fighting in a public place, and resisting an officer or obstructing without violence. I've read these 2 charges. I find probable cause on both counts. I also note that Mr. Stein is currently equipped with an ankle monitor as part of his pretrial release in reference to 151862 CF10A for aggravated battery with a deadly weapon, currently on pretrial release. Can someone confirm that for me?
Yes, Your Honor, and it actually involves somewhat similar circumstances. In that case, it's alleged that he was acting belligerent and hostile towards staff and customers at a UPS store that actually not very far from where this allegedly occurred in Lighthouse Point. He was escorted out of the store. He then allegedly, when he got to his car, allegedly struck someone in the parking lot intentionally with his vehicle, Your Honor. Now he's being alleged today, once again, yelling profanity, screaming at workers and staff at a Bobby Rubino's, Your Honor.
So if I may,
Yeah,
Judge.
Hang on, sir. You have a lawyer speaking for you, Mr. Riddell.
excuse me. I need to talk to my lawyer first. There are facts that he doesn't know that I know.
You want to reset his case, sir? What do you want to do? So I'm just
I
gonna
want
talk.
to talk to him just for
Sir,
a minute.
okay, I don't care what you really want right now. If you'll just hang on, your lawyer's here, okay? Just be patient.
Thank you.
Thank you.
I'd like to address the court with a couple issues, Judge.
All right, fire
I was
away.
in a pro bono capacity. I started helping Mr. Stein. I was in front of the judge on Wednesday of last week, in front of Judge Contini on an emergency basis in regarding why he is currently on pretrial. In regarding his pretrial, there was Judge Contini let him out with a couple caveats of things to do immediately. Mr. Stein wasn't released until almost the end of the close of business, late Friday. He came to my office. I actually secured him a ride to go to his house. I haven't spoken to him since his release, but after I met with him to get him a ride, I did learn that Mr. Stein's power was turned off in his home. All his property was being held. The jail wasn't able to release his property because of a disconnect in regarding what they had his middle name in. I planned on going before Judge Contini in an emergency capacity. I would ask the court at this time to not revoke his pretrial release and to ultimately defer on any decision of that, and we could maybe set this for tomorrow in front of Judge Contini and we can go from there.
Well, I still have 2 charges pending here that I've got to deal with.
I agree, Judge, and I'm asking the court to defer on those at this time. I'm happy to meet with Mr. Stein and talk to him. We could roll to tomorrow morning and I could further address it.
You want to put him back on for another PC hearing tomorrow?
Yes, Judge.
Well, Your Honor, what my request would be is if it's going to be deferred for Judge Contini to decide, I would ask that he be held on the pending case to ensure that he does go before Judge Contini tomorrow. And then if Judge Contini wants to put him back on pretrial, he can do that. If he wants to...
With Judge Contini's case. Okay, I'm going to reset this case till tomorrow.
Well, then-
And if you want to go talk to him at the jail, you can.
Thank you,
And
Judge.
whoever's here tomorrow can deal with it, and Judge Contini can deal with it.
Morning would be great.
Resetting your case until in the morning, sir, and the lawyer will be over to talk to you. Good luck.
Thank you, Judge.
Thanks, Coach.
I mean, I got to stay in jail today? That's BS.
I'll do it immediately. Thank you very much, Judge. We'll see you in the morning.
All right.
Thank you
Good
for
luck,
your
sir.
courtesy.
Nicholas Wren. Nicholas?
This is Mr. Riddle.
All right. Good afternoon, Mr. Wren. Mr. Wren, you're charged with several cases here. DUI or alcohol first offense, DUI with damage to property on counts 2, 3, and 4, and a traffic violation, failure to use due care. Give me just 1 second, sir, to read the rest of this PC. Does he have a record of all?
No, Your Honor.
All right, these are pretty serious allegations with respect to what happened in this event, but it doesn't appear that anybody was seriously injured. On counts 1, 2, 3, and 4, I find probable cause to believe you may have committed the offense to which you're charged. Count 5 is a failure to use due care, which is a traffic offense. Count 1, the bond is $500. Count 2, 3, and 4, the bonds are $1,000. Your total bonds are $3,500. Good luck to you, sir.
Judge, can we offer up some ties to the community, perhaps get this bond lowered a little bit?
Well, I might consider it on one of the property damage, but on anything else, no. I mean, this is...
Well, he's a 2-year resident in South Florida, been at the same address the past year and a half. He works at Ethan Allen. He's been there for 3 years. He does have some money in the bank. No real estate. He's hoping his mother or his family will bond him out.
What do you do at Ethan Allen, sir?
I'm a design project manager.
Sorry, I didn't hear you.
I'm a design project manager.
All right, on the property damage, one of them was a bike.
Yeah.
The other one was
Thank you.
moderate damage to the right rear bumper. On count 2 and 3, I reduced the bonds to $500 on each of those, so your total bonds now will be
$2,500?
$2,500.
Thank you, Judge.
Good luck to you, sir. Stay out of trouble.
Good luck. Thank you, Judge.
Roberto?
He's at North Broward.
Thank you, Counselor. All right, Roberto. You speak English, Roberto? Speak English? Yes? Don't be shy. Sir, you're charged with a violation of probation or community control. A warrant issued by Judge Porth out of the criminal court. Therefore, there's no bond in your case. You're going to have to see Judge Porth, and your hearing will be 4/16 at 3:30 in the afternoon, it looks like. 8:30 a.m. on 4/16. So you'll be held until then. You'll have to see the judge to resolve your case. Good luck to you.
Thank you.
Roberto Zayas? You speak English? Yes? Sir, you're charged with possession of a controlled substance without a prescription. Give me 1 second, please.
2007, he went through drug court for possession of cocaine, marijuana, and drug paraphernalia.
You take them on pretrial release after they've gone through drug court and are charged with a new drug offense? Yeah, he's got 3 packets of heroin on him. Pretty strong drug. What did you say is, you said, Mr. State Attorney, the last thing he had was just drug court?
Yes, 2007.
Where do you live, sir?
His mic's not on.
Can you turn the microphone on? Where do you live, sir?
77 Sim Street, Hollywood, Florida.
How long you live there?
For almost 22 years.
You work?
Yeah, I was. I lost my license.
Where were you
I'm trying
working?
to fix my license. Truck driver.
Truck driver?
Yes, sir.
Sir, if you've got a drug problem, you need to get this straightened out.
I know.
This is, you're never going to get a job and you're never going to be employed if you don't get this straightened out. What'd you say?
Mm-hmm.
So they might have.
Well, what about, if this guy's got a drug problem and I put him on pretrial release, how's he going to pass the drug test? All right, sir, listen to me, if I place you on pretrial release and you got a drug problem and you start failing the urinalysis or whatever they're giving you for screening, you're going to be back in jail. Do you understand?
Yes, I do.
Are you going to be able to keep clean and pass these drug tests?
I believe so.
All right, I'm going to take a chance on you, sir. I normally set a bond on this with heroin, but this young lady in here is adamant that you're going to somehow pass, so I'm going to put all the onus on her and you. We'll write his name down, and I'm going to check back in 6 months.
There. Take this.
Thank you, Judge.
All right, thank you.
Down the middle, please.
Can I ask you by his name, please? Osvaldo Alberto Isquinero. That's a great name, sir.
Judge, Mr. Osvaldo is, he's present at the main jail. Judge, he believes that his license was reissued back in November. According to the PC, it was suspended in December. He believes it was because of child support issues.
Because of what? What'd you say, child support?
Child support issues.
Let me get his record.
He's advising that he was not aware of the suspension. We asked the court to consider pretrial release or ROR on this case.
All right, the first problem is, nope, I got it.
My mother needs me.
All right, let me just run down your record here, sir, so we all know what we're dealing with. Operating a motor vehicle, no proof of insurance. Driving while your license was suspended, 10/19/2014. Seatbelt violation, 3/29/14. Seatbelt violation, 4/11/13. Driving while your license was suspended, 5/30/2012. Driving while license suspended, 2008. Driving while license suspended, 2001. Let's get up to the present time here. Habitual traffic offender declared 12/10/2014. 4/8/15, failed to pay a traffic fine. Failed to appear in court for a traffic summons. Failed to appear in court on a traffic summons, 4/13. That's just the last few days. And then, suspended in Miami-Dade, failing to pay a traffic offense. 1, 2 times. Those may be the same thing. And then Lee County, failing to pay a traffic offense. Not doing very good with the traffic court, sir. He's charged with driving while the suspended license habitual. Might be inclined to increase that bond. What, do you work, sir?
Judge, good afternoon. It sounds horrible, habitual traffic offender.
Yeah,
I have not had a ticket. Yeah, I have not had a ticket for speeding or red light or a stop sign. In these instances, child support, sometimes it was a day late. In one instance, I paid made the payment at 12:30 and it had to be before 11:30, so it came as the next business day. And my address in Cape Coral, I go there only like every 2 months. My mother has had 6 different strokes. She's completely incapacitated in a wheelchair. I'm taking care of her here with my sister, and I, in those instances, I was not aware that it was suspended. Then I make the court requirements. I went back. I got my license back, and then a similar situation happened. For 1 day or 2, it was suspended, but I made the payment for child support, and then again this happened. I was not aware that the 3 times in 5 years would have been that horrible name, traffic offender. The last one that was issued to me was in November, and I paid and I made.
I honestly don't know from your traffic record anything about the child support issues that you're raising. That's a possibility, but it appears. Okay, it appears to me that all of these violations that led up to your indefinite suspension were traffic violations, seatbelt, license, not showing up in court, etc. You were suspended on 12/10/2014 for 5 years as a habitual offender. So I find probable cause.
No.
I find probable cause. I increase your bond to $1,000. I'm sorry you're in your predicament, but you've certainly known that you were declared a habitual offender. Whether they were right or wrong, I don't know. Your bond's $1,000. Good luck to you, sir. Stephen Harmon. Stephen Harmon.
Main jail.
Stephen, you're charged with violation of probation or community control, unfortunately. This arises out of the criminal court. Judge Contini has issued a warrant. Therefore, there's no bond in your case. I find probable cause. Your hearing is 4:15 at 8:30 in the morning. 4:15.
You'll see the judge on Wednesday.
Good luck to you.
Boyce, William Boyce.
William Boyce.
15, William Boyce.
Boys.
I think he went outside.
One moment, Judge.
Okay.
Mr. Boyce is present and approaching. He's declined the PD.
Thank you. Okay, you're charged with striking a Michael Altman, sir. Yes,
sir.
Misdemeanor touching or striking a battery. You're also charged with a probation violation. On the battery, I set your bond at $1,000 and find probable cause. Because it's an allegation you violated probation or community control, there's no bond. You'll see the judge on April 15th, which is this week, to try to resolve your case. Good luck to you, sir.
Thank you, sir. Do I have bond?
Yes, you have a bond. $1,000. No, you've got a no bond hold until Wednesday. You're going to see the judge on Wednesday.
So I gotta stay in jail?
Until Wednesday. Day after tomorrow.
Robert James Ferraro.
Ferraro, present. Is he bond? 15.
Ferraro.
He's present at the main judge. He declined the public defender. Ferraro.
Ferraro.
Oh, did we want to do those municipals, or what do you all want to do on those? It's 2:15. I don't want to keep anybody holding. What do you want to do? Just keep going with this docket? He doesn't look like he had that many more in jail.
This is Mr. Ferraro, Judge.
All right, Mr. Ferraro, you're charged with possession of PVP. His field test positive on the drugs. Therefore, there's probable cause to believe you may have been in possession of this drug. Does he have any record, Mr. Attorney?
Your Honor, what I see, 1996 reckless driving, 95 possession of marijuana paraphernalia, 94 possession of marijuana, 94 possession of marijuana paraphernalia.
Nothing even in the 2000s.
No.
You work, sir?
Yes, sir.
Where do you work?
Neighborhood plumbing.
Neighborhood plumbing?
Yes.
That's a business?
Yes, it is.
And what do you do there?
I'm a plumber.
How long you work there?
I'm a licensed plumber.
How long you work there?
4 years.
How long you lived in Broward County?
All my life.
Okay. You have resources to post a bond in this case?
Yes, I do.
All right. Because of his ties to the community, I'll reduce the bond to $500.
Well, Your Honor, if the court is going to reduce the bond, then we would ask if you consider some combination of pretrial release. The substance that he's alleged to have been in possession with, the common street name is known as Flocka. And Your Honor, I don't know if the court's aware or not, has been becoming a bit of an epidemic problem in Broward, associated with acts of violence also, Your Honor. So I would just ask that the bond either based solely on the concern of the nature of the drug that he's allegedly in possession of, either the bond be kept in place or a pretrial where he could be tested, and if he continues to use, then he could potentially be faced being held in
Well,
custody.
I'll consider putting him on pretrial. You going to be able to pass the requirements of pretrial release if I release you, sir?
Yes, sir.
You going to be able to pass drug tests?
No, it's fun.
Well, maybe not today, but you understand that's going to be a requirement of being on pretrial release, not under the influence of drugs or alcohol. You going to be able to do that?
Yes, sir.
All right. Place you on pretrial release. No bond, ROR and pretrial release.
Thank you, Judge.
Good luck, sir.
Jackson.
Christopher Jackson, Chris.
Yes, sir.
Whatever you want.
Hey,
Tricarico.
Ferraro.
Can you stay outside here, man?
Are you Lewis? Louis Tricarico?
All right, sir, you're charged with possession of cocaine. Field test positive, 0.5 grams of cocaine, so there's probable cause in your case. Does he have any kind of record? You're also charged with trespassing, a minor offense in light of this. Mr. State Attorney is on the phone. I'm going to...
Your Honor, we can get you
Jackson, yeah.
I will.
That's it? He's been verified for pretrial release. Mr. Jackson, you're going to be able to pass all the requirements of pretrial release. You're going to be drug tested and screened randomly. You can't be under the influence of drugs or alcohol to be on pretrial release. Do you understand?
Sure.
You going to be able to do that?
Don't see why not.
Don't see why not? All right, well, take your best shot. You'll be back in jail if you don't. Good luck with you, sir. You'll be on pretrial release.
Yes, sir.
ROR, pretrial release. Put his name down by her, too. I think she's going out on a limb on her also.
Good luck. Down the middle, out the door.
Thank you.
Good luck to you, sir.
Thank you, Judge.
Okay, so what do we want to do, counsel? Keep going? Louis Tricarico. Louis,
Bonded, Judge.
thank you. Kamiko Wilkinson.
North Broward.
That's North Broward, Your Honor. Come on.
All right, sir. You are charged with 3 cases. Possession with intent to deliver cocaine, possession with intent to sell, manufacture, deliver cannabis, and possession of drug paraphernalia. Give me 1 second, please, sir. Smoking marijuana in the laundry room.
Judge, would the court make, or if the court wants me to, I can make inquiries as to his ties to the community for bond purposes?
Yeah, just give me 1 second. Let me finish this.
I know,
16 small bags, field test positive marijuana. Cigar tube containing 5 crack cocaine rocks, field tested positive.
Yeah, I understand.
Residue scale. Post Miranda, the defendant admitted ownership of all the narcotics and the scale. All right, any record on him, please? 2014? He's got a cocaine case?
2013, aggravated stalking. 2013, domestic violence battery contempt. And the priors are on 12.
All right, sir. In count 1, I find probable cause. In count 2, I find probable cause. And in count 3, I find probable cause. All right, counsel?
Mr. Wilkinson, can you afford a $3,600 bond at this juncture if the judge kept the bond as it is?
No,
How much could you afford?
nothing really. I'm just
Okay.
hoping somebody's phone me up.
What city do you reside in?
Oakland Park.
How long you been living there?
Off and on, straight since 2009, but off and on since 2002.
How long you been a resident of South Florida?
Since 2003.
Do you have family down here?
Yeah.
Are you currently working?
Yes.
Where do you work?
And D&D Auto.
How long you been working there?
For the last 2 months.
Okay. Do you currently rent or own your place?
I'm staying with someone.
Okay. Judge, I have nothing further. Will the court consider releasing the pretrial release? He has no funds right now. He is gainfully employed, but is unable to post bond. And
He has extensive history, including drug cases pending in 14. He's caught red-handed with all of the drugs, field test positive. The bond in count 1 is $2,500. The bond in count 1 is $1,000, and the bond in count 3 is $100. You'll have to post those bonds and see the judge, sir. Good luck to you. Giovanni Caesar Yesbeck.
President of Maine.
Count 1, 2003. Count 2, just what the schedule's on there. Main jail. You're Mr. Yesbeck?
Yes, sir.
All right, they're telling me your bond was posted. You'll be released, sir. Good luck to you. You'll be released.
Good luck.
Bond's posted. Johnny Allen McLean.
He's president of the Maine, Judge.
Possession of cannabis. 1 second, please. All right, 0.13 grams of suspected cannabis. Open side driver's door. He also found under the stereo bag containing 41.97 grams of cannabis. 3 clear zip-sop bags, 11.47, 15.80, and 14.7 grams of marijuana. Field test positive. Loaded .40 caliber weapon in the car. All right, sir, you're charged with really just 1 count, possession of cannabis over 20 grams, which I find probable cause on. Do you have any record on him?
2012, he pled out of carrying concealed firearm to carrying concealed weapon, Your Honor.
He's not charged with a weapons violation here, even though he had a weapon with him.
Yes, that'll have to be looked at for when a filing decision is made, Your Honor.
So you only have a weapon charge against him in his career?
Yes, Judge.
All right, well, he has a sufficient amount of marijuana here to justify the bond. The bond will be set at $1,000, sir. Good luck to you.
Judge, this is a first felony offense for Mr. McLean. He does have a job. He's been working at Lowe's for 5 years. He's been living down here for 15. Can we consider pretrial?
Your Honor, I would just argue, I think an argument can be made based on the amount found that it is for more than just personal use, especially that a
Well,
firearm
he had a
is
weapon
found.
on him, and he's already had a weapons charge. That concerns me. So the request for pretrial will be denied. I'll keep the bond at
Thank you, Judge.
$1,000. Good luck to you.
You're like the eighth defense
Random
attorney.
Wayne
I
Romero,
don't know which ones you guys are covering
possession
in
of
on.
PvP.
President, the main judge approaching.
I can get free trial, man.
Oh, all right. Who did? The judge heard it? I don't know. I don't know. I mean,
All right, sir. The drug FLACA, or PvP, was field tested positive, found on your possession. There's probable cause to believe you may have committed the offense to which you're charged, possession of PvP. Do you work, sir?
Judge, he works at Don Bailey Carpets. He's been there for about 8 years. He grew up down here in South Florida. He's been at the same address for the past year and a half. No money in the bank, no real estate.
yeah, Mr. Romero comes through here a lot. He was arrested mid-February for possession of cocaine, and the state has not been able to file charges yet. He was released ROR March 23rd. He has, since November 2011, he has 24 arrests.
Are those all drug charges?
Most trespass, cocaine. It all makes up.
All right, sir. I'll set your bond at $1,000. Sir, if you have a drug problem, you really need to think about getting some help here, because it seems to me, just based on what I'm hearing here, you're being rearrested for the same kind of offenses.
He
You
walked
need to look
away,
at getting
Judge.
some help, sir. Good luck to you. Jacqueline Milligan,
North Broward.
possession of weapon or ammo by a convicted felon.
Judge, I don't have a probable cause affidavit.
You have a capias on him, that's fine.
Is it a capias, not in custody capias? And not
Yeah,
magistrate?
Rod Singal, failing to appear.
It's not from failing to appear, Judge. It was for
Oh,
whatever
it's an
reason it
original
was.
charge out of criminal court.
He wasn't arrested at the scene.
Right.
It looks like, and
We got a warrant from Judge Singal with a bond already established. There's probable cause based on his warrant and the PC that's attached. All right, sir, you're charged with possession of a weapon by a convicted felon. The bond's already been set by the division judge. Your bond is $2,500. You'll have to post that bond and see the judge.
no, I know, I'm telling you. Yeah.
Did you want to say something, sir? I can't do anything about your case, whether you're guilty or innocent. I'm here only to set the bond, and there's really little I can do because the division judge has done that.
Okay, I was wondering if you could let's set my bond a little lower, cause I gotta start work and I can't. I work for Las Olas Bull Factory, and I ain't gonna if I don't that money cause I was out on bond to revoke my bond, cause something that I had got arrested for, they didn't charge me, and then when they found out I was a convicted felony for the brass knuckle,
So
the person.
The problem is, this bond and this warrant was issued by another judge, which I cannot really disturb. So I'm sorry, there's nothing I can do. The bond will be set at $2,500. You'll have to go see that judge to get it changed. Good luck to you.
Okay.
Jarvis, Roy, what is this? Oh, this was the guy earlier?
No, Judge. This case is not on the docket.
Okay.
It's actually a case that's been magistrated before. I'm asking, Mr. Linder doesn't have an objection to it.
He wants to get his phone, okay.
He wants to get his phone property. I just need to send that to the attorney, that's all.
Patricia Coate?
We're still waiting on a private attorney, Judge.
Oh, okay.
The alleged victim is present in court, though, Your Honor.
How about Tony Shipman? That looks like a reset.
That's a municipal ordinance case.
Oh, MOs? 130. Oh, I see. These are 130s. So are you done there, I think, sir, in the jail? I don't see anybody else, do we?
You got it.
Judge, we have this coat here, and we have a bunch of misdemeanor ordinance cases, and we have some second looks.
All right, well, I got the MOs. I think the lawyers are here. Chris Brown, is that the lawyer?
Yes.
Did anybody try to get a hold of him?
Your Honor, you also have an interpreter case.
It's really,
What?
Case, I don't know which one.
Yeah, we have any
Just call me.
cases?
Your Honor. At this point, as far as procedurally speaking, it's really up to Ms. Cote or Cote. The court can reset it till tomorrow morning because she should get up to 24 hours to have a private attorney present, or if she wants to proceed now, then she can waive, have
So
and
she
have the
isn't
public.
magistrated yet.
No.
Well, I'll bring her up and talk to her in a minute. Counsel, did you say Patricia Cote is still there? Can we have her? Where's she at?
Approaching, Judge.
All right, Ms. Cote, apparently they tried to contact your lawyer, Mr. Brown, this morning unsuccessfully. I can reset your case until in the morning, and you'll have to stay there. I can determine conditions for release if you so desire. What is your desire, ma'am?
I want to go. I want to be released.
Well, I'm not saying I'm going to do that. I'm saying I'm going to hold a probable cause hearing, determine what's probable cause, and set a bond. Or if you want your lawyer to be here when I do that, we tried to get him twice. You can wait until tomorrow and see the lawyer.
Okay, one moment, Judge.
Victim's here?
Yeah, she's present.
I'm assuming that's someone related to him. Ms. Cote? Oh, wait, she's talking to the lawyer. Okay. Which case are you here on, sir?
Okay, Judge.
I'm sorry, one second. What? What'd you say, counsel?
Ms. Cote is ready to speak.
All right, what do you want to do?
I want to waive my. What do I?
Want to waive your attorney?
I want to waive my attorney.
All right, you want me to set conditions of release. First, you're charged with touching or striking during domestic battery. I reviewed the probable cause affidavit and find there's probable cause to believe you may have committed the offense to which you're charged, which is a simple battery during a domestic violence event. Hang on, don't say anything. There's someone here in the courtroom. Raise your right hand, sir. Swear affirm any testimony you're going to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Okay, I'm not here to decide whether someone did this or didn't do that. That's not my job. It's only to determine conditions of release and setting a bond if necessary. So with that in mind, what do you want to tell me, sir? Tell me your name first.
Sure, my name is Christopher Cote. I'm the victim, but more importantly, I'm her husband. We've been going through a divorce. Things got a little hot last night. She's not a violent woman. We're really good at pushing each other's buttons, and she does not belong here, and she doesn't really belong in this situation. We just need to take care of this situation on our own, and if you could just let her come home.
Your Honor, she has no record. As far as bond, Your Honor, I'll leave that in the court's discretion. I'm not worried about her fleeing or committing any kind of crime spree. I do think for the time being that there should be a no contact order. We have allegations of kicking, punching, biting. I think it's best to ensure that this doesn't happen in the immediate future, that the two of them stay away from one another for now.
Judge, would the court, based on a lack of prior record, consider releasing her on our own recognizance and entertaining an order of no contact with the husband?
Well, I'm not on DVs. I normally
Do you have children with him?
not on the DOT generally, but I am going to set a minimal bond in this case, and I am going to also issue a no victim contact. I'm going to set the bond at $100. You're going to have to post that bond to get her out, sir. I'm also ordering that she have no contact with you because you purport to be the victim. This is an order from me. Now, you guys need to work this stuff out through the lawyers in the domestic violence division,
yes, sir,
through your divorce or whatever. But for certain, based on what's happened here, her being arrested, because the police don't have much discretion when they come out there and there's alleged domestic violence. They're going to arrest somebody generally. So you need a cooling off period between you two. Whatever that is, you guys need to dictate that. But the first thing you need to do is, if Mr. Brown's your divorce lawyer, you need to get in touch with him and get this stuff sorted out through the domestic court. I'll set the bond at $100. You'll have to go over and post the bond. She'll be released upon the posting of the bond. She's not to have any contact with you directly or indirectly once released. Good luck to you, sir.
I shouldn't take her home?
Sorry?
Shouldn't take her home?
Well, you heard my order. You guys do what you want to do out there, okay? Good luck.
Go that way.
Jail and post the bond. She'll be released.
Guillermo?
All right, now I'm on municipal.
Judge, this is Guillermo Rojas. He's the municipal ordinance on page 8. He's also a Spanish language. We need the interpreter for him.
Oh, she's here. Perfect. Page 8? I don't know the paperwork, do I? What's his name?
It's a
Oh, I
reset
got
from
it.
this morning, Judge.
I got it, Rojas. I got it. All right, our interpreter's here. If you swear her in for us. These are municipal ordinances.
I believe Mr. Atria was here, and it is.
I do. Alicia Stegman, certified court interpreter.
Judge, I believe there's no city public defender or no city prosecutor here, and it's a critical
These are
stage.
all municipals.
Yeah, and
Well, there's a
normally
public drunkenness. Is that a state statute?
I don't.
There's public drunkenness, $100 bond.
I think
Sounds
it's
like a
still
state
in this.
statute.
Who's the
That's a misdemeanor ordinance capias, Judge.
It is? Okay. Oh, yeah, you're right. I see it now. I apologize. So the other two, he's got an open container and an open air lodging, sleeping on the street, I guess. Where'd all our lawyers go? The municipal lawyers?
You still got a few.
Oh, where's
Is
this?
this a Fort Lauderdale case, or what city is this?
This is City of Hollandale. What am I going to do? Reset the case?
Judge, well, I'd hate to lose our interpreter. I actually have an interpreter case for the second look docket if you want me to bring him up now.
Okay, but what am I going to do with Mr. Rojas? Reset his case till tomorrow and notify the City of Hollandale?
Well, Judge,
De Hallandale no tienen el abogado.
Judge, I would argue that absent the presence of the attorneys who have every opportunity to be here, the court should consider ROR on all counts.
And frankly speaking, it's your call, because really no other party that's present has any standing to make
Well,
any
how
argument
does
or
the city get
suggestions.
notified to be here?
Your Honor, frankly, I don't know, because this is a municipal ordinance.
He got a record?
If, as a friend of the court, if you want me to check, I can
Ordinancia municipal.
inform the court.
Well, I mean, he's going to get picked up again for sure if he's got a
Eddie, do you
extensive
have a-
record. He's at the same place. So
Eddie, do you have a
I don't see any
BCC?
reason not to ROR him, and then he'll have to answer all of these things.
682 392.
But I didn't see. What I don't know is how we notify the city on these things to be here. I'm going to talk to Judge Weinstein about this again.
Please.
You know what, Mr. Attorney? I'm going to ROR him. Okay.
Your Honor, you
ponerlo
can
bajo
give
su
whatever you
propia
want.
palabra.
He'll be ROR'd, sir. You'll have to answer for these
Está bajo
charges.
propia palabra, pero
Not getting
tiene
a free
que
ride.
encarar
You'll have to
estos
come back and answer for
cargos.
these charges.
Tiene que regresar para encarar
IPC on all
estos
three
cargos.
cases.
Okay. Judge, could I ask the
Buena
court,
suerte.
if the court would remind him that it's his responsibility to follow up with any court
Yeah,
dates?
yeah. Thank you, counsel. Sir, it's your responsibility
Señor, es su responsabilidad
to find out when your court date is set
averiguar cuándo se fija su caso
on these three cases.
por estos tres cargos.
All I'm doing right now
Todo lo que estoy haciendo ahora mismo
is releasing you.
es dándole libertad.
That means you still have to come back and
Quiere
answer to
decir que
these
tiene que
charges.
regresar para encarar estos cargos.
So you have to contact the clerk's office,
Así que si usted tiene que contactar al secretariado
find out when
judicial
your court date is,
para averiguar cuándo es su fecha judicial
and appear in court.
y aparecer en tribunal.
If you don't,
Si no lo hace,
a warrant for your arrest.
voy a emitir una orden por su arresto.
Understand?
¿Entiende?
Sí, señor.
Yes.
And you'll get notice through the mail, but I doubt he has a permanent
Le
address.
van a dar notificación por correo, pero dudo que tenga
You have a permanent
dirección
address?
permanente. ¿Tiene dirección permanente?
Sí.
What
Yes.
is it?
¿Cuál es?
725 Northeast,
725 Northeast,
7th Street,
7th
Hallandale,
Street,
Florida.
Hallandale, Florida.
All right, I'll give it to the clerk.
Apartment,
Se lo voy a dar al secretariado.
I think he was trying to give you an apartment number, Judge.
You sure it's not
114.
Northwest?
114.
¿Cómo el departamento?
Sir, this says 725
Uno-
Northwest 7th Street.
725 noroeste.
Apartment.
7 calles,
Apartment.
dice aquí, Northwest.
Apartamento 114.
Apartment 114.
Okay, is it northwest or northeast?
¿Es noreste o
Northeast.
noroeste?
Northeast.
Northeast.
No, así.
Good luck to you, sir.
Buena suerte,
Northeast,
señor.
Judge.
Can you change it to northeast?
Sí, mire, tiene que esperar afuera.
All right, good luck. Okay, now I got misdemeanor. Do we have second looks?
Judge, I have a second look.
Yes,
It's,
I have a second look
because
at North Broward, Sladen, Marvin.
Okay, Antonio
Come on,
Bonilla Maldonado.
Stand on the X.
All right, I'll be with you in the jail. Just one second there.
Okay, give me a minute.
All right, I got Maldonado Bonilla. He's been in jail 6 days, charged with petty theft, resisting a merchant without violence. It's about time to resolve his case or do something, isn't it?
Se le acusa de robo menor y resistir a un mercancía
I don't know
sin violencia.
his history, Mr. Attorney.
One moment, Judge. Looks like he has.
I don't speak Spanish.
I'd have to put him into the system again to see.
All right, we need a Spanish on him. All right, Mr. Maldonado,
Señor Maldonado,
I'm taking a second look at your case. Just be
estoy
patient.
tomando una segunda vista a su caso. Sea paciente.
You want to resolve your case today, sir?
¿Quiere resolver su caso hoy, señor?
Sí.
Yes.
Looks like out of Puerto Rico, 2010 burglary, 1998
Era un
attempted murder.
allanamiento en el 98 de Puerto Rico e intento de
What the
homicidio.
system showed.
Out of Puerto Rico?
Hey.
Yes,
De Puerto
1998.
Rico.
He's still discharged with petty theft. This looks like a shoplifting of some kind.
Just saying this is why it was not resolved the first time through.
All right, sir. Do you want to plead no contest to the charges of petty theft and resisting a merchant?
¿Quiere declararse no disputa a robo menor y resistir a un agente de una tienda?
I'll send you to time
Sí.
served.
Yes, le sentencio a tiempo cumplido.
Okay.
What you
Gracias.
want to do?
¿Eso es lo que usted quiere hacer?
All right, the
Thank you.
disposition, there will be time
Thank you.
served.
Hey.
No contest
Yes.
to count one, no contest to count two. Time served.
Thank you, Judge.
Thank you, counsel. Yes. Yes.
I think they have a Spanish one over at North Broward, Judge.
Mark North Broward. All right. Do you speak Spanish, sir?
¿Habla español, señor?
No, sir. No, sir. If you're talking to me.
Okay, hang on, sir. Sladen's in the main jail, isn't he?
Yeah.
Is there a mark on Sladen there?
North Broward.
Can I see Sladen first, please?
Yes, sir.
That's you?
Yes, sir.
You don't need a Spanish interpreter?
No, sir.
Does anybody else need a Spanish interpreter?
¿Alguien más necesita intérprete en español?
What's this other case here? Anthony Walker.
Those are motions to release on the felony docket.
These are MOs, which we don't know what happened on them. Shipman and Vaughn. Doesn't sound like Spanish. Okay.
Okay, thank you,
ma'am.
Judge.
All right, Mr. Sladen, you're here on a second look, sir. You've been in jail 6 days. You're charged with criminal mischief, $200 or under. You're arrested
Yes, sir.
for 8. What kind of record do we have on Mr. Sladen?
Well, he was arrested in mid-February for, hold on, Judge. The screen's a little frozen at the moment, Your
Do
Honor.
we happen to have his PC on this second look, Madam Clerk, or not?
Be on the computer. Eddie, do you have in your?
May I speak
Sladen,
to you,
do
Judge?
you have his report?
You do have it? Thanks.
Look at everything first.
You work, Mr. Sladen?
Sir, I had to be honest with you, that was what happened with the car. I was actually doing a video at that
All right,
time.
sir, wait. Don't say anything about your case, because I'm not here to resolve it. I'm just here to see if I can resolve it without listening to testimony. So just be patient a minute. I'm looking at what happened here, okay?
Yes, sir. No, what I was saying that's my job now. I do video. I'm starting to do music. That's what I'm saying. And I got a little hyper, so that issue was, a little out of hand on my case. I got a little hyper, but at the same time, that's my job. I'm doing music. That's what I'm gonna make all my money.
Okay. If I resolve this case, sir, you're going to have to pay restitution for this damaged car.
But yes, sir.
Your Honor, just to bring to the court's attention, he was arrested mid-February for possession of PvP and resisting without violence. Allegedly kicked at the officer 3 times when he was brought to the hospital. That a final decision still hasn't been made. Last year, 2 counts of assault. Last year, disorderly conduct, trespass. 2014, possession of PvP, sentenced to 150 days.
There's no way I'm doing anything in this case. All right, sir, your bonds will remain in
Hey,
place.
sir.
There's nothing I can do in your case with your criminal history.
Can I please speak to you, please, sir?
Speak to
Please,
who?
sir.
Who do you
Can I
want to
speak to you just for 1 minute? You, sir.
Sir, you can tell me
Please.
whatever you want, but you've got to keep in mind, everything you're saying is being
All right.
recorded. If you make any admissions, the state attorney can use that against you. I'm not
All right,
changing your
sir.
bonds. That's the only reason I was looking at your case, but your
What
criminal
about-
history will not let me do
What
it.
about his pretrial release, Judge? I noticed that what they mentioned 2 PvPs, but maybe you want to place him on pretrial release.
No, there's no way. I'm sorry. There's just nothing I
Hey,
can do.
sir, can I please speak, sir?
What do you want to say, sir?
Sir, listen, on my past record, sir, I was around the wrong crowd. A lot of things happened, and I got accused for a lot of stuff, sir. And I was honest to the court and told you I admitted that when I got a little out of hand. But, sir, my past record was just from drinking, and I stopped drinking, sir. That's what I'm trying to say. I done slowed down. I'm really in the process of changing my life. There's a lot of good things that's going to happen in my life now.
Your Honor,
That's
it's
what I mean. I have
$100.
nobody.
Frankly,
I don't
Bond
have.
is only $100.
this is his 9th
I
arrest
have-
in less than
All right.
in about 2
All right, Ms.
years.
Slayton, I heard your piece, sir. Your bond
I
is only
have
$100.
nobody.
Your bond is
I
only
don't have
$100.
nobody. I
Good
don't
luck to
have
you, sir.
nobody
Have a
to
good day.
burn me out,
Take
sir.
him away. Thanks.
I have nobody
Good
to
luck
burn
to
me
you,
out,
sir.
sir.
All right. What about these 2 municipals?
I
Anything to do on these?
Just for the court, or do the same thing.
Yeah.
Council's not present. And
Was this City of Fort Lauderdale?
No.
Somebody was here. Who was that guy?
From Fort Lauderdale, Drew Atria.
He represents the city of Fort Lauderdale.
Why'd he leave?
No, he doesn't represent the city.
Oh, we don't have Fort Lauderdale cases.
Doesn't represent
Okay,
the
so
city
these
of
are
Fort
other
Lauderdale.
cities? Yeah,
No,
Laura
but-
are both of them.
No, I know, but I'm just.
Wait a minute, I got a capias on one of them. Is that from county court? This is possession of a controlled substance. I got a different case.
Who's this on?
Tony Shipman? Who?
Marty Levy.
Marty Levy Cohen. Well, these folks, are they here? Is that him? Is that Tony Shipman?
Yes, it is, Judge.
Oh, okay, sorry. All right, you're here on an original case then, on a capias out of the county court for possession of a controlled substance. It's like Judge Wren, maybe. The bond is $100. There's probable cause in your case. Your hearing is, it looks like 414 or 419. I can't make that out. So your bond is $100, sir, and you're going to have to see the judge. 417. Either you post a $100 bond, or you'll see the judge on the 17th, which is, I guess, a week from today. All right?
Judge, this is the kind of case that can sometimes be resolved, but without any of the parties present, they can't resolve it. Is there any chance the court could consider ROR now that he does have his court date?
Does he have a record?
Do you have?
I don't have the underlying PC. I just have possession of a controlled substance.
Okay, let me see.
He only set a bond of $100.
I'm sorry. How do you spell his last name?
Shipman. And
Shipman.
you want this number up here on the right?
Oh, the BCCN number. That if you have it. That.
561 500. Oh,
Oh, never mind. All right. It's okay. I'll get the information you need. Judge.
I've got it. 155-848.
Okay.
But still, you don't have the city prosecutor or the city attorney here at a critical stage of the proceeding. Will the court
But
consider?
this is a
If this is a capias.
this is a possession of a controlled substance. This isn't an MO.
It is an MO.
It is an MO case,
It is an
Judge.
MO?
Yes.
But,
You have
Your Honor-
nobody
What is
here
it?
from Fort Lauderdale.
Alcohol? What do you got on him?
As far as prior state charges.
Do you have a permanent address, Mr. Shipman?
Sir?
Do you have a permanent address?
Yes, sir.
What is it?
2800 Northwest 5th Court.
Well, what's located there? Got a home, an apartment?
It's a house.
And who lives there with you?
My girlfriend.
Why did this address have 635 Northwest 8th Avenue?
I moved, sir. That's one of my old addresses.
How long you lived at that address?
It's been about like a year now.
You work?
Yes, sir. I'm a concrete finisher.
How many RO are you, sir?
Yes, sir.
Thank you, Judge.
Good luck.
Jerry Vaughn.
Jerry Vaughn.
Judge, this is Jerry Vaughn, Judge.
Yes, sir.
Morning, Mr. Vaughn.
Good morning.
All right, we got panhandling prohibited. I'm assuming there's a record on him, right? Sorry. What are we doing with these cases? Is
It's
it
the same
panhandling? It's an MO. Sure, he's got a record of some kind.
Just as the same situation as the previous two municipal ordinance cases, there's nobody from Fort Lauderdale, either city prosecutor or city defender present. With the court consider releasing them on their own recognizance. It's a critical stage of proceeding. Nobody's here.
All right, what's
Your Honor,
his
just to bring to the court's attention, this is just as a friend of the court, so you're aware. Every single time he's been arrested, I say it last 5 or 6 times, it's always been on capiases. An ROR will most likely, I don't see how it won't result in him being arrested on a capias again.
But the thing is that
All right, it is what it is. He's ROR. Good luck. Good luck, sir. I got one other folder up here. I don't know what this is. Is this for me? Corrected capias? Anybody got any idea what this is? Corrected capias. Anthony Walker.
These are 30
He's at
days,
Conti, Your Honor.
What'd you say?
Anthony Walker is at Conti.
Judge, Mr. Walker, it appears, is being, it looks like it's an ROR hearing. I'm not sure if it's a 30-day motion or not.
Well, this is the original charge. Possession of, looks like PVP. The bond is set at $10,000 by the originating judge, Judge Singal.
Yeah, we're just here to see that the state filed an information. I provided, Your Honor, with a copy of the Register of Actions from the clerk's office, which shows that the state, last Friday actually, did file an information.
But the information's been filed. The bond has been established at $10,000 by the division judge. So that's the disposition. There's probable cause. The bond will be $10,000. You'll have to post that bond and see the judge, sir. Good luck to you. Jerry Vaughn?
Just did that.
Oh, we did that one? Sorry. Oh, I did ROR. What do you want me to do?
Judge, I think we're done with the regular docket. We're now on to the second look docket exclusively.
All right, I got some more second looks here, it looks like. Anthony Walker, we just did him, right. Okay, so Michael Wilson?
Charges have not been filed. He can be ROR.
Conti.
All right, sir, the charges haven't been filed in your case. You're going to be ROR. Good luck to you.
Thank you. Your Honor.
Next is Daniel Supinski.
Conti.
Got him. It's a hearing on a motion for grand theft auto. Did you file charges?
Yes, Judge.
All right, so your charges were filed in this case yesterday by the state according to the docket. You're charged with grand theft auto. Do I establish a bond, or what is that worth?
No, it's already been established. This is just to inform him.
Oh, yeah, the bond's been
charges have
set at,
filed.
does that say $1,000?
Might be. I don't know off the top of my
All
head.
right, sir. In your case, the charges have been filed. You'll have to answer to the charge of grand theft auto. Good luck to you. You can still post your bond. Next case is Reynold Charlieu?
Conti, Your Honor, Conti.
Charges have not yet been filed. He's entitled to release today.
Charges have not been filed in your case, sir. You will be ROR'd. That means they'll release you. Good luck.
Thank you.
Fred Hayes?
Main jail.
Main jail?
Charges have not yet been filed. He's entitled to release.
Charges have not been filed. You'll be ROR'd, sir. You'll be released. Good luck to you.
Thank you, Judge. We are now clear at the main. I'm going to sign off.
Good, thank you. I think we got one left at Conti, maybe. I saw someone.
Sir, Your Honor. Conti has two.
Brian Hibbs?
Paul Ryan, Your Honor.
Paul Ryan, thank you. You're Mr. Hibbs? Yes. Mr. Mr. Hibbs, they're handing me documents showing that charges were filed against you yesterday, or Friday, and you were charged with burglary of an unoccupied structure. So the bond has already been established in that case. Looks like maybe $1,000. So you'll have to post the bond and see the judge in your case, okay? Good luck. Back to Conti.
Conti has two more guys, Richard Clem and Wesley St. Jean.
Where's William Rice?
St. Jean was put on the second look docket. I can explain what's going on in Mr. St. Jean's case.
All right, well, let's do them in order so I don't get confused. I've done all these 3 pages, so we're up to William Rice, right? Are we up to William Rice? All right, where's William Rice? Anybody know? Gone? Left?
Well, he can be ROR'd.
All right, he'll be ROR'd. He'll get the good news later. I have Richard Clem.
Conti?
Yes, Your Honor.
Your Honor, we're actually going to be declining charges, so he's entitled to release.
They're going to decline charges, sir. You'll be released. Good luck to you.
Bless you, Your Honor.
Bless me. Thank you.
Judge Wesley St. Jean is on the docket. Mr. Miller was able to get this docket on.
I'll find a way.
Get this matter on the docket.
Wesley St. Jean, okay.
Reason it's set on the docket is he's currently in mental health court. He was conditionally released to the program. There's a bond on his misdemeanor case which wasn't resolved, and I'm asking the court to release him on his own recognizance so he can go to the program. We called Marge. Well, Judge, the only thing that's preventing him to go to this program, I would like the court to emphasize to the court that his felony charges, he's released to a program. The only thing holding him in custody is this charge. If we, that's another day that he'll sit in custody. He doesn't have the ability to bond out. He is indigent. And I'm just asking the court to entertain the ROR order.
Well, what's the state say?
One moment. Yeah, I have to look this up, Judge.
If the state doesn't object, I will, but I don't have any paperwork now as a clerk. Unfortunately, may have to reset him, but if the state doesn't object, then I'll adhere to your wishes, sir. I'm sorry, I didn't hear you. Do you know what the underlying misdemeanor charge is? False ID, thanks.
I have no objection, Your Honor.
All right, he'll be ROR'd on the misdemeanor charge. Can we
I'm gonna ask that it be the same conditions as everything else.
Well,
It looks like he was given.
So now they can. The only thing
I'm looking at a separate misdemeanor case where he was given the same pretrial Elmo as the same felony cases. All I'm asking is that everything be treated the same. I have no objection to him being
I'll
released.
treat it all the same and ROR him so he doesn't have to post a bond on it.
Thank you, Judge.
All right, so make sure you get the paperwork to the clerk because no one has anything up here. So I'll have to sign a separate order on that. All right, so you're going to be ROR'd on your misdemeanor case and you'll be going to the mental health court to get some services over there, all right? Good luck to you.
All right.
Have a good day. I think we're done, right?
I know, I'm telling you.
I'm doing it right now. He's writing just as you're talking. All right, so let me turn everything off.